last week before coming here to just seek some clarity on some housekeeping issues. And the housekeeping issue I had was to check, because it's on the public domain, that Mr. Maleka had represented in the recent past parties that have got an adversarial relationship with the companies that I since bought, and whether am I going to get a fair treatment, or maybe it's got some unfinished business with the companies, because I would imagine that if you're representing a client against some other people, there is some element of buy-in into what your client is saying and so on. So whether coming here, he's got some unfinished business and all that. And so I thought, as part of the opening yesterday, my mind was going to be set at ease. But then, Chairperson, what then happened yesterday, Mr. Maleka's posture actually confirmed my fears, because his posture yesterday was prosecutorial as opposed to evidence leader. And I'm not so sure as to what is happening now, because I came here with the pretext of answering questions to assist the Commission. But I feel that I'm the accused as it is right now. And I've got a prosecutor here who is Mr. Maleka, who is busy cross-questioning everything, and I've got no problem with that. But the issue I'm trying to understand is, why is this posture only reserved just for me? Other people have been here saying all kinds of things without producing any evidence. They were never asked to verify this, verify that. And here, I'm here treated like a hostile witness, so to speak. So I'm not understanding, why am I getting this kind of a treatment in this? In fact, Chairperson, you might know this, that there are some people that wanted to come here. And they said, with the treatment that they saw being dispensed with me yesterday, that they're no longer coming here and so on, because of what happened yesterday. And then the second question, Chair, I had asked yesterday, without understanding again how the Commission works, because when I'm asked a question, I'm supposed to respond on the spot. But when I ask a question, I don't know when it gets responded to. I had asked that my understanding of what we're dealing with here, we're dealing with the state capture issues and all of that. Now, I wanted to know the emails that were in my pack here, and those emails did explain that they were all emails that relate to when I was not in the public service, as it were. I was in the private sector, writing or getting invitation emails. There's not even substance on those emails to indicate any unlawfulness, as it were. So I just needed to get a context of why when private people are sending emails to each other, getting invited to this function or that function, or I'll send a CV here, or that kind of a thing. I needed to understand, why is that an issue here? Because there are many other people who have sent CVs to that I'm not having to respond to. So I was not sure those too many issues, Chairperson. Thank you.
Well, thank you, Mr. Manyi, for raising whatever concerns you may have. One, I am not aware of the letter or email that you said you sent to the Commission, and whatever questions you asked. Was it addressed to the Secretary, or was it addressed to any particular person?
It was addressed to, the only contact person I have for the Commission Chair is Mr. Mabunda, and he did respond in writing, and responded and said he has forwarded the email to the team. So I assumed then that when I get here, the team would have deliberated and they would set me at ease.
Yes.
But that has not happened.
Yes, no, he would have meant the Commission's legal team, if he said he had sent it to the team. I will let Mr. Maleka say something in case he is aware of that letter, and then we'll take it from there.
Okay.
secondly, with regard to how Mr. Malega, as you put it, was posturing when he was asking you questions, this is what I would like to say. The approach of the Commission is that the Commission's legal team doesn't have clients, so to speak, or its own witnesses as such as you would have in a court when a lawyer has got a client and they are his or her own witnesses that they will call. But they seek to bring evidence before the Commission, and that evidence may prove or disprove allegations that are being investigated, and that when they ask questions to any witness, they are free to ask questions, including what may be viewed maybe as difficult questions, in order to try and establish the truth. Now, it may well be that it might be difficult sometimes to draw a line between a time when a member of the legal team is asking difficult questions, that might not be an accurate term, and a situation where they would be seen maybe as cross-examining. You know, in the rules of this commission, I think most of the time in relation to the legal team, what is used is simply that they have a right to question and to ask questions aimed at establishing the truth. So, to the extent that you may have concerns, one would need to just see, as I say, there may be situations where it's difficult to say, is this somebody who is just trying to get the truth out of the witness, or get what he believes, are the answers that will satisfy the needs of the investigation of the Commission, or is it somebody who has gone beyond that line? As I say, it can be difficult sometimes to make that distinction, but you are free to raise your concerns as we go along, and I will apply my mind to whatever concerns. I will be watching, I'll be listening, and I do want each and every person who appears before this commission, whether they are implicated or not implicated, to leave the witness stand feeling that they have been treated fairly. That doesn't mean that they will always get what they want. It doesn't mean that there won't be situations where they feel uncomfortable, but I am committed to doing what I can to make sure that they experience fairness in this commission. Okay. So, one, I think maybe Mr. Malega, if you know anything about the letter, let me know.
Yes.
But I would say I would like to see that letter if it exists in due course, sometime this morning if possible, and I will have a look at it, and I will do what I can to make sure that in one way or another there is a response to the issues that you may be raising there. So with that understanding and subject to what Mr. Malega is going to say, you don't have a problem if we continue in the meantime?
Yeah, I think he must just, Chairperson, reflect on how he's been doing all along before I came and try and be consistent. The view I have and the view that has been corroborated by a lot of people that called me yesterday is that I got a very different treatment than others that were here. Mm. So if he can just try to be consistent to maintain the credibility of this commission.
Yeah, okay. Thank you. Mr. Malega, you wish to say something about the letter, and I think there may be one issue that Mr. Manyi raised, which I just remember now I didn't mention.
Yesterday, our leader, Mr. Paul Pretorius, handed to me let me describe it as a letter, dated 18 November 2018.
What's the date?
18 November 2018. It comes on the face of it, not from Mr. Manyi, but from an organization titled Anti-Poverty Forum. And it raises a number of questions.
Well, let me just check if that would be the letter. Would that be the letter?
No, Chairperson.
It is not.
Mine was just an email to Mr. Mabunda.
Oh, it's addressed to Mr. Mabunda. And Mr. Mabunda doesn't happen to be here. You don't know anything about that?
No, I don't know anything about it.
Yeah.
I can place on record that Mr. Pretorius told me that this letter raises a number of questions about our right to be here and ask questions on grounds similar to those raised by Mr. Manyi. And he asked me to respond to it so that the full perspective can be placed before you to make a ruling. But as far as I understand, there is neither a formal application from this organization or from Mr. Manyi to request that you should rule us out of the commission. I can assure Mr. Manyi, Chair, that I did not appoint myself to this commission. I can assure him that we went through a rigorous process of accreditation. And ultimately, there is nothing untoward arising from that process. I can assure him that we are governed by strong rules of ethics about our conduct. And I can assure him that as and when we raise questions from him before you, we are subject to tight rules of control by you. And if we behave untoward or inappropriately, you will rule us out of order. And I can assure him that if the concern is I have previously acted for other clients, and for that reason I may not have a perspective of impartiality when I ask him question, that is not the case. Our rules of professional ethics require us to act for every person in the street who approaches us for as long as we are available to do so. I can place on record that I have acted for a number of people who face allegations of impropriety before you. I have completed those cases. As and when they come here, my ethical duties to the Commission will be different. I can place on record that he approached me at some point to act for him. Unfortunately, I was not available to act, but if I was available, I would have acted for him. That's the extent of the impartiality which our profession calls us to uphold, and I'm willing and able to uphold it before you. So in that context, and against that background, Chair, with your leave and subject to any objection Mr. Manyi may have, may I continue?
Let me say first, one, I think the letter that Mr. Pretorius gave to you is a letter that he got from me. I think there were two letters, one, or no, maybe it may have been one, but it may have mentioned both you and him. And the idea was that you, both he and you, would comment on its contents and the allegations, and then that would be given to me. So when you are able to do that, and then there would be a response to the organization that wrote.
Yes.
That's one. And two, I'm sure that somebody within the legal team or the administration, I see Dr. Devier is there, will make sure that the letter that Mr. Manyi says he sent to Mr. Mabunda is made available in the course of this morning to the legal team and to myself, so that one can look at that and take it from there. And then I will just make sure that in one way or another, Mr. Manyi gets responded to, if at all possible, depending on the view I might take after reading the letter. I'm not sure how much information it requires, maybe today or as soon as possible after today. But as I understand it, Mr. Manyi has indicated that subject to what he has indicated, he does not mind that we continue, but he just had the requests that he made. Mr. Manyi, am I right?
Yeah, you are right, Chair, up until Mr. Maleka responded. I must say, Chair, I'm very disappointed by his response. I think if he can play tapes of what he's been doing all along until I came, and compare to the tape that how he conducted himself when I was here. And if Mr. Maleka cannot see the difference between how he treated other witnesses versus what was subjected to here yesterday. I mean, here, Chairperson, you're sitting with, I have not been subpoenaed to be here on these matters. I was subpoenaed to only talk to the SMS. I came here voluntarily, but I'm put here on a stand as if I'm this criminal and so on that is lying. And other people that were here, their evidence was not interrogated or whatever they said, because they didn't even produce anything. Their poetry, which they were reciting here, was not interrogated, but me, every step of the way, I had to be interrogated. If Mr. Maleka sees nothing wrong with that kind of inconsistency, which I was assuming that as an honorable person, you would acknowledge that, and then we can move forward. I can't move forward then, Chairperson, with a person who cannot admit when something is so blatantly wrong. So I request that he must recuse himself, and any member of the other legal team can continue from where he left off.
Well, if you request that he recuses himself, that's quite an involved process. We may have to subject to what Mr. Maleka has to say, we may have to stop at this stage and give you an opportunity maybe to prepare a statement that sets out exactly what your grounds are. You articulate everything fully so that when a decision has to be made, whether he must recuse himself or not, there is something in writing that articulates the reasons properly, and it may be necessary to, put together other facts. And then at some stage before you continue, that would have to be that may have to be decided. That is one option. Mr. Malega, what do you have to say about this objection?
Well, Chair, I mean, if Mr. Manyi feels uncomfortable, we should follow process, and I'll be guided by you, but if there is a need for a formal application for a recusal, on the strength of which we have to respond, then let it be. It may well be that the Commission's time resources will be wasted until that application is decided, but I have no difficulty with it.
Yes, yes. So I think, therefore, if your request for Mr. Malega's recusal stands, I think that we would have to stop with your evidence at this stage and then give you an opportunity to, I know that you did say that you are not legally assisted. I don't know whether you would be intending to be legally assisted when you prepare whatever documents you need to prepare or not. And I'm asking that simply because if you will be legally assisted, I might not need to explain much because whichever lawyer will be assisting you will explain. But if you will not be legally assisted, I may have to explain some one or two things. But it may be that you are not sure as you sit there whether you will need to be assisted or not. So in which case you can just tell me at this stage you are not sure.
Chairperson, I think this process should be open to a man on the street. This process, it can't be a process that is meant for only those that are moneyed, as it is. So I would rather take the posture of saying I will not be legally assisted, and if the chairperson can assist me to prepare or whatever, I'll be happy to take that assistance.
Yes, okay. One, if there is a lawyer who offers to assist you subject to your being satisfied about who he or she is that something you would entertain, or is the position that you just want to deal with it on your own?
No, I can entertain that, Chair.
You want to deal with it on your own?
No. I'm saying if there is a
lawyer who can assist you free of charge, for example.
With that, Chair. I had also requested this assistance from GCIS, in fact, initially. And but the processes there are not as quick.
All right. I just say in public that if there is any lawyer who can assist Mr. Manyi to bring the application that he wishes to bring, who will be prepared to do so free of charge, I would encourage them to do so and be in touch with him. That's number one. Number two, in case you end up dealing with it yourself, what we would require is an affidavit in which you would say that you are asking that Mr. Malega should recuse himself, and you detail your reasons for it and any facts which you believe support your request. Detail that in an affidavit, and then send it to the Commission, and then once it has been received, you will be informed of what is going to happen after that, because the legal team may want to prepare something in writing in response, which and you would be entitled to receive a copy in advance, and whether to decide whether after that you would like to respond to that. And at some stage then we will fix a date when we can deal with that request in an open hearing.
Okay. Can I just check one thing, Chair? Are we saying that as we sit here and now, Mr. Maleka is the only person that is on a ready mode because to ask whatever questions, because the questions were actually given, they are written. Are we saying there is no other legal person right now that is able to take on from here instead of prolonging this thing?
No, we are not saying that, but what would have happened, but he can tell me because I wasn't there when they were preparing. Sometimes it's one person who is preparing in regard to a particular witness, and I think sometimes he or she may be preparing together with another colleague, in which case, if, for example, there is another colleague who is just as familiar with everything, that other colleague of his might be able to say, I can take over, either immediately or be given some time to refresh his or her memory and then be able to proceed. So I think your suggestion is maybe we can avoid all of that if another colleague of Mr. Maleka, I'm sorry. I apologize, Mr. Maleka, is available. Yeah. Mr. Maleka, I've apologized.
Chair, I have said to you that we have a leader who designs the implementation of the Commission's mandate. I did not appoint myself to ask questions of Mr. Manyi. It is the leader who has done so. And just to comfort Mr. Manyi, the leader decided that I and Ms. Hofmeyer, or Ms. Hofmeyer and I, should attend to matters relating to TNA and GCIS. And it is in that context that I find myself asking Mr. Manyi these questions around GCIS and TNA. If, and to the extent that you are persuaded after consideration of his application that I'm not fit for purpose, then that won't be the end of the day for the Commission, because Ms. Hofmeyer may well be able to take over. But I emphasize it should be after you have considered and decided the application once brought. It is unfair to our colleagues who have not prepared on this to start trying to fit into our shoes. It would be unfair to Mr. Manyi too, because they would not be able to deal with the truth as far as it's necessary for you to pursue it. So my humble suggestion, for what it's worth, is that there has to be an application. You have to consider it and decide it. And thereafter you may give directions around how his concerns may well be adequately catered for.
You see, the way I look at it provisionally in terms of his suggestion is this. We can take one approach that says, look, there must be an application first, and it must be dealt with properly and decided. And that would mean, obviously, adjourning his evidence, and that would have to be dealt with at some stage in the future, which might not be before we take the December break, which might take us to when we resume next year. Another approach might be one that says, irrespective of whether or not his objection to you is has merit or not, it might be more it may well be an option to explore, to say, well, if he has an objection to you, but somebody else within the team who can do the job, given some time, can do it, and we finish with his evidence, it may be that for practical purposes, one could look at doing it that way without saying that his objection has merit or not. So simply say at a practical level, and to make progress, maybe we should do it that way. There may be criticism for that approach. There may be something good and practical about it. The one part that would be good is that we are able to make progress and finish his evidence and move on, you know. And then we take it from there. So, but maybe what we should do is, because I see your leader is also not here, I assume that he is available in the next building.
Yes.
Maybe we should adjourn. We should stand the matter down, so that his evidence down for now, and then to allow for the head of the legal team to get involved and discussions to be had, so that then at some stage later we can then reach some finality.
Yes.
And in the meantime, it may well be that we may have to allow the next witness to take the stand. We interrupt his evidence. That's not something that I prefer, because I would have preferred that we finish with Mr. Manyi's evidence. But it may well be that the practicalities are such that while discussions are taking place as to what should happen, if possible, we should use the time for the next witness that's available. So those are some of the things I have in mind.
Chair, can I say two things before we adjourn?
Yes.
I understand the utility of trying to find a middle ground in the interest of the Commission's time and financial resources. And of course, I support it. But there are two things that I'd like to place on record. The first thing is that you are confronted off the mark with a request from my recusal based on matters that raises questions about my professional integrity. I own nothing in life except my professional integrity. It is my tool of trade. And to the extent that it is being questioned, I would ask for an opportunity to respond to it. It is for that reason I would urge that there is some utility in the application for recusal, so that I or others who may well advise me properly would have an opportunity to respond to it. Second, it would be a sad day that witnesses come before you and choose who must ask questions of them, because we might be setting a precedent which will begin to limp the Commission in its important duty to discover the truth. For those two reasons, I would ask you to seriously consider the utility of an application for recusal.
Thank you. Mr. Manyi, you want to say something?
Yeah, two things, Chairperson. I think, firstly, the response from Mr. Malega is, again, very regrettable, because he postures as if it's somebody that was just innocently asking questions yesterday, when in fact he was not doing that. He was doing more than just asking questions. He crossed the line of just asking questions and was actually cross-examining me. And this is the issue, Chairperson, and the issue about cross-examining me may not be wrong per se, but what is the issue for me is that why is it that I'm the first witness to get this kind of this hostile cross-examination that was subjected to by Mr. Maleka. So that is the one issue, Chairperson. The second issue, depending on how we proceed, Chairperson, if we're going to stand down or whatever, I just need an opportunity to clarify just one thing from my deposition yesterday.
Yeah.
Okay, what I needed to just clarify, Chairperson, of all the questions I was responding to, the question that was I did not give a clear answer on, because on the issue around the spend, where I didn't give a clear answer on, because also my posture coming here was really to say that the notion that TNA has got more than its fair share is actually misguided. That was my approach. But when we went to the nitty-gritty about City Press and so on, and I had said that City Press is probably 80 or 90% of that EDS 24 figure that was there, and I maintained that position. But then I think I needed to explain, which I didn't do yesterday, that, okay, now what is this 199,000 for City Press Chairperson? Now, I just needed to just clarify that very quickly, just to simply say, Chairperson, that firstly, indeed, in that EDS 24 spend, there's a lot of City Press in there, as I said, most likely 90% plus, so I'm not changing that position. Then, what then happens, Chairperson, at a practical implementation is that we've got this, call it sales house or marketing arms of these groups. Naspers has got EDS 24, Black Tissue has got another one, I don't know what it's called, but it's Avusa something at the time. So you get these companies that do group purchasing for their various companies and so on. But then, and these are the companies that GCIS will be dealing with in the main. But then that does not stop some regional person somewhere from having a relationship. It's a thing that we try, I think GCIS are trying to clean up over the time. But what that happens, Chair, before you come in?
I must just stop you, Mr. Manyi. I thought it was just a brief clarification.
You have to 30 seconds, Chair.
You will get a chance when you are able to come back and continue with your evidence. You must just make note of the point you wanted to clarify further so that you will remember it. Because you have raised an objection to Mr. Maleka, we should not, until we have resolved that issue, continue.
Okay.
Mr. Maleka, what is your position about whether or not you may desire to consult with your leader before we finalize anything? You would like that?
Chair, I agree that I should consult with my leader, but in the interest of time, the next witness lined after Mr. Manyi's evidence is available. He is available.
Yes.
And I suggest that we take a 15-minute break so that I can consult with my leader and Mr. Mokoena can prepare himself to lead that evidence.
Okay. It's now nearly 9:45. So let's take an adjournment until 10 o'clock. Would that be fine?
Chair, should we leave it on the basis that we'll come to you? It will certainly be 10 or immediately after 10.
Okay, all right.
Mr. Mukwena has just whispered that 10:15 might suit him.
Okay, all right. Let's take the adjournment, and so that Mr. Maleka can consult with the head of the legal team, and we will resume at 10 or as soon thereafter as possible, but not later than 10:15.
Thank you, Chair.
And Mr. Manyi would be informed once you have consulted of the view you take in regard to the issue, and we'll come back and I will indicate what's to happen.
Thank you, Chair.
Okay. We adjourn. Yes, Mr. Pretorius.
Morning.
Good
DCJ.
morning.
Chair, following certain discussions that have taken place during the adjournment, I'm informed by Mr. Manyi that he does not wish to proceed with the application for recusal, that he is prepared for Mr. Maleka to ask questions, and that if he has any difficulties in relation to any particular question, it may be raised with you in the ordinary course and you will rule, Chair. So the evidence of Mr. Manyi will proceed. That does involve some delay in calling of the next witness, Mr. Mantashi, and we apologize for that delay, but it was unforeseeable. And thirdly, Chair, I understand that prior to Mr. Manyi continuing with his evidence, you intend to make a statement from the Chair. Thank you, Chair.
Yes, thank you. Mr. Manyi, would you wish to confirm what Mr. Pretorius has told me in regard to your intentions about the objection to Mr. Maleka?
Yeah, thank you, Chairperson. Yes, my words were, I don't want to be a reason to frustrate the work of the Commission. I think the point has been made, and I believe that from here on, Mr. Maleka will take all of that on board. Thank you, Chair.
Thank you very much, Mr. Manyi. Thank you, Mr. Pretorius. Before we proceed, I wish to address certain matters that I intended to address earlier. I realize that I probably was mistaken to think that the room would be fuller in terms of the media at this time. So I will go ahead. Last week, a protest was staged outside the building in which the hearings of this commission are taking place. This occurred on the 3 days on which Minister Pravin Gordhan was giving evidence in this commission. During that protest, certain statements were made concerning Mr. Gordhan and the head of the Commission's legal team, Mr. Paul Pretorius, SC. The statements included insults directed at Minister Gordhan and Mr. Pretorius. It has been necessary to secure the transcript of the proceedings in which those statements were made before one could deal with them. While this commission has no desire to get involved in any political disputes that may exist between Mr. Gordhan and any of his political rivals, this commission wants to make it clear that it is unacceptable for anybody to subject any witness appearing before it to any form of harassment or intimidation whatsoever. A witness who appears before this commission and gives evidence does so in order to help this commission with the matters that it is investigating, and such a witness acts in the public interest. If no witnesses were to give evidence before this commission, this country and the whole nation would not be able to get to know whether state capture occurred, how it occurred, who was involved in it, and its full extent. Nor will the people of South Africa know the true nature and extent of corruption that has engulfed our country, which this commission is required in terms of its terms of reference to investigate. Therefore, it would not be possible to determine the most appropriate measures that should be adopted in order to eliminate corruption, or at least to drastically reduce the levels of corruption in our country. I have, over a number of months, called upon past and present members of the National Executive, Directors General, and other government officials or employees who have knowledge of activities relating to state capture and corruption to come forward and assist the Commission with its work. Some of the past and present ministers have come forward to do so. These include Mr. Gordon, Mr. Nene, Mr. Jonas, and Ms. Barbara Hogan. Indeed, this morning or today, we are going to hear the evidence of one of the present members of the National Executive, Mr. Mantashe. Any harassment of witnesses appearing before the Commission will deter other potential witnesses who otherwise may have wanted to come forward and give evidence and assist this Commission. This will seriously undermine the work of the Commission. I therefore urge all South Africans and all other people and organizations who are committed to a proper investigation of the allegations of state capture and the extent and nature of corruption in our country not to do anything that may jeopardize the prospects of success of this Commission's work. Any harassment of the personnel of this Commission is also unacceptable. I take this opportunity to once again point out that anybody who has a complaint against any personnel of the Commission or other persons assisting the Commission is free to lodge their complaints with the Commission, and the Commission will consider such complaints properly and advise them of the outcome thereof. In this regard, I point out that the best way to get the evidence leaders of the Commission to raise certain issues with witnesses is to furnish them with evidence concerning what that witness is alleged to have done, so that the witness may be called upon to deal with those issues or allegations. It does not help the Commission nor the country for a person who has evidence implicating a witness appearing before this Commission to keep that evidence away from the Commission and not hand it over to the Commission. Anyone who has evidence of any corruption falling within the terms of reference of this Commission, or who has evidence of acts of state capture which he or she believes is credible, should hand it over to the Commission. Otherwise, if he or she fails to hand it over, many people will believe that he or she does not believe that that evidence is credible and will stand the scrutiny before this Commission. This Commission will not consider what is said outside of the Commission and in the media if it is not brought inside the Commission. Minister Gordon came to give evidence in the Commission voluntarily and was prepared to have his evidence tested by way of cross-examination. Anyone who has credible evidence concerning any alleged wrongdoing on his part should himself or herself come forward and present that evidence. This Commission is fully conscious of the enormity of the assignment given to it. and is ever aware that it is required to try and complete its work as soon as possible. It must not allow itself to be distracted, but must focus on the work it is called upon to perform. For now, the Commission will not itself be laying any complaints with the police so that it can continue to focus on the work it is called upon to do. When in breach of the regulations of this Commission, the media published witnesses' statements before those witnesses gave evidence before the Commission, and without the written permission of the chairperson, which is a criminal offense in terms of the regulations, this Commission did not immediately lay any complaints with the police. And in this case, this Commission will not lay any complaint with the police at this stage, but will monitor the situation and the conduct of various people in regard to the Commission and in regard to witnesses who appear before it. And when it considers it appropriate to do so, it will not hesitate to lay a complaint with the police. It is important that this Commission and all its personnel are given space to focus on the national assignment that it has been given and to do its job without any distractions. In this regard, I do want to emphasize that anyone who has complaints against members of the legal team or members of the investigation team should once again feel free to lodge complaints, and those will be considered properly. And if there is any misconduct on the part of anybody, the Commission will deal with that appropriately. Until evidence has been placed before the Commission which reflects that any one of the members of the legal team of the Commission has been involved in any misconduct or unacceptable conduct, I, as the chairperson of the Commission, continue to have confidence in the whole legal team of the Commission, including its head, Mr. Pretorius. I continue to have confidence also in the investigation team, and until there is evidence placed before me which I assess to reveal misconduct or unacceptable conduct, I will continue to accept that they may continue with their work. This Commission will continue to do all it can to encourage persons who have information relating to the matters that it is investigating to come forward and share their evidence with the Commission in the interests of the nation and in the interest of establishing the issues that this Commission is investigating. It is hoped that from now on, all concerned will allow the Commission the space it needs to do its work and to support its work. But any harassment and intimidation of any witness appearing before this Commission to assist it will not be acceptable, and this Commission will continue to look at how it can protect all those who appear before it in order to assist it. One of the statements that was made last week in the protest that took place outside this building was a statement to the effect that this commission decided to use this building without looking at the possibility of using government buildings, or a statement was made that this commission should have been using government halls or government venues in order to reduce costs. I just wish to make it clear that after I had been appointed as chairperson of this commission, I gave an instruction that those who would be looking for a venue that the commission would use, which was Public Works and the Department of Justice, assisted by the secretary of the commission, I made it clear to them that the preference should be to use government venues so that we would reduce costs. Indeed, I was told that various government venues were inspected and for one reason or another were either are not available or not suitable. I will mention some of these that were considered. They are Sporal Park Office Building in Centurion, Tshwane Municipal Building, Centurion, Kempton Park Civic Center, Kempton Park, Emoyeni Conference Center, Parktown, Johannesburg State Theatre, Bramfontein. So I just want to make it clear that this commission and Public Works and the Department of Justice did not simply go for a privately owned building without exploring the possibility of saving costs and using a government venue. But on the report that was given to me, none of the places that were looked at was available or was suitable for the needs of the commission. That is the statement I wanted to make, and that is the end of that statement. Thank you, Mr. Maleka. We may continue.
Thank you, Chair. Mr. Manyi, if we could just orientate ourselves where we were yesterday. We ended when we were discussing the various revenue earned by entities that compete for government business in regard to government advertisement spend. I'd like to start elsewhere this morning, if you don't mind. And I'd like to start with your explanation that you have adequately answered our concern regarding how you were transferred to GCIS.
Well, I'm sorry, Mr. Maleka. Earlier on, when we were still not sure whether we would continue with Mr. Manyi's evidence, he had indicated that there was a point he wanted to clarify, and I indicated that he would get a chance to do so when we resume. Maybe let's give him a chance to clarify that point. Mr. Manyi.
Thank you, Chair. Yeah, the point I wanted to clarify, Chair, was I was saying that yesterday I didn't give a clear response to the City Press as an example question. That how is it that City Press will get so little, so to speak? And I had originally said that the City Press, as an example, is loaded into that H24. But then it was shown, I think what I should have clarified yesterday is that it appearing as a line item elsewhere does not preclude it from being at the center in that big spend. So what happens at a practical level, Chairperson, is that what you find is that big groups like Tisoplex would have a marketing arm that houses all the, that does all the work to procure adverts for their publications. But the fact that they have a centralized place that does that, it does not stop an independent title like a City Press or a Sowetan on its own to have a bilateral of sorts with any other party. So I suggesting, Chairperson, that City Press and all these one-item things, what typically happens sometimes is that when you have a quick project and you have to meet a regulatory requirement, for instance, you want to quickly advertise for a job, and then you then just quickly, the regulation would say 2 national newspapers. For that specific thing, you would then quickly just go directly to City Press or Sunday Times or whoever, as opposed to go to their central place, which does that. So this is what happens in that case. So the fact that we have 199,000 or something is a total misrepresentation of amount of money that goes to City Press. And as I said, a lot of it is in that central figure of EDS 24. So that's a clarification I wanted to give, Chair.
Okay. Mr. Maleka, do you want to take
Chair,
that?
can I, with your leave, follow up on this, because it is going outside the context and the business of where the Commission is.
Yeah.
Mr. Manyi, can I make it quite clear that the questions that I asked of you yesterday and the answers that you gave yesterday related to the figures that you produced about only that part of revenue, and by competing newspapers from one source of revenue, and that is the government's expenditure on advertising through the GCIS. I'm not asking all you to deal with issues relating to other source of revenue by the newspapers. Are we at one on that score?
I think you're missing the point. The point here, Chair, is that all those line items that are there, it's money from GCIS. All that is money routed through GCIS. So I'm saying sometimes you get a direct, let's say even GCIS would do a direct City Press ad hoc. Yes, and ad hoc. Those are other, let me characterize them as ad hoc placements in those other newspapers, as opposed to your general campaigns that you do, and then when you do that, then you speak to the consolidating house, as in EDS 24 or whatever is other group company. So all of them is still from GCIS. So I'm not understanding why Mr. Maleka is struggling to understand this simple point.
Chair, I will deal with it on the assumption that Mr. Manyi's context is correct. I don't want to waste time. Okay. I will assume that the clarification he has given confirms the figures that he has produced and which he accepts they are correct. So I will deal with that issue on that approach. But with your leave, that's where I don't want to start this morning. I want to start elsewhere this morning.
Yes.
Mr. Mayor, just to go back to where I think we should start this morning. You recall that yesterday you indicated to the chairperson that the information you have now presented, especially page 229 of Exhibit M1, resolved all of the questions that we raised with you about your transfer. You recall that you said that yesterday to the chairperson?
Yeah, yes, I do, Chair.
I'm afraid it did not resolve some questions that we would like to explore with you, if you don't mind. You answered our query with reference to Section 12(1) of the Public Service Act. But we would like to ask you some few questions around the lawful requirements for a lawful transfer of a Director General, such as you were, and a Director General, such as Mr. Masako at the time. We have placed before you an exhibit bundle as F1. Chair, that is the bundle of Ms. Williams' testimony. We have asked your registrar to bring it for you this morning and place it before you.
I've got a number of exhibits with red covers here. Registrar, which one is it? Okay, I've got it, exhibit F1.
Indeed, Chair. Mr. Manyi, do you have exhibits F1 before you?
Earlier on I had, but now I've got H1 to H5.
Can I ask colleagues to place a copy of exhibits F1 before you? Chair, may I ask you to turn to page 75 of exhibit F1?
A 75, you said?
Indeed.
Yes, thank you.
And Chair, just to lay a contextual basis for the questions which will follow, remember that Mr. Manyi, in his statement, referred to section 12(3), subparagraph A, which reads as follows: the President may transfer the head of a national department or national government component before or at the expiry of his or her term or extended term to perform functions in a similar or any other capacity in the national department or national component in a post of equal, higher or lower grading or additional to the establishment as the President considers appropriate. And as I understand the testimony of Mr. Manyi yesterday, is that his transfer was lawful because the President considered appropriate to transfer him. Now, Mr. Manyi, can I ask you to go to page 76? And ask you to consider with me what subparagraph D of section 12(3) of the PSA provides. And let me read it together with you, Chair. A transfer in terms of this subsection may only occur, and I emphasize the phrase only occur, if, Roman 1, the relevant head of a department consents to the transfer, or after due consideration of any representation by the head, the transfer is in the public interest. Do you see that, Mr. Manyi?
Yes, I do.
I take it that you have worked with this legislation and you know what it requires to justify a lawful transfer, correct?
Yeah, Chairperson, I'm not understanding what is it that is not clear here. In my input yesterday, I did indicate that I had a discussion with Minister Chabane. So in terms of Roman figure 1, in terms of the conditions that Mr. Maleka is reading here, where the relevant head of a department consents to the transfer, which is me, I consented to the transfer. So I'm not understanding what is outstanding on this matter.
Yes, let him put his question. Mr. Maleka, put your question.
Let me start where I thought I had started and repeat the question. And frankly, ask Mr. Manyi to answer that question, rather than anticipate what I might not ask. And the question simply was, this is not the first time you see this provision. As the head of the department, you must have seen it, you must have considered it in your lifetime as a Director General of more than one department. Is that a fair summary of what you should know about this legislation?
I note that, but it's not necessarily true, Chairperson, because it talks about transfer. So when you are appointed in the department, I don't think issues of transfer is something that comes top of your mind. So it's not an automatic something that you preoccupy yourself with.
So would you say you may or may not have seen it at the time you were Director General of one department or another, but you can't really remember? There was no issue that may have required you to focus on it?
Correct, Chairperson. That's a correct summary.
Okay.
Whether you have seen it before or not, you will then accept that one of the most important requirements for a lawful transfer is that you should have consented, correct?
I did say I did consent, so...
No, Mr. Manyi, we'll get to that point and we'll explore it to see whether or not you consented. The question is different. And the different question is this. A lawful transfer under Section 12(3) would, in the first instance, require the consent of the affected Director General, correct?
Proceed.
Well, Mr. Manyi, you may, if the question, if you think the question is legal and you are not a lawyer, you are uncomfortable committing yourself, you can indicate that you think it's something legal. But if you think it's simple, you can answer it. You can answer it. Do you want to say anything?
Yeah, Chairperson, D has got 2 Roman figures. It's either or. So when a question is asked in the manner that is asked, as if there's only one answer to the question, it creates a confusion, because you can be transferred, in terms of my understanding of what I read here, Roman figure 2, if it's in the public interest. You may not yourself consent to it, but a call can be made that is in the public interest. So when I'm asked a question when I'm asked a question as if there's only one answer, I just feel that it's sort of inappropriate.
No, well, let me just say this, Mr. Manyi. Just feel at ease. If you are asked a question as you say it, your understanding that there are 2 scenarios, but you are asked in a manner which you think suggests there is one, feel free to say that can be the case, but it can also be another case. Just feel free and answer as you see the question.
Yes, Chair, but then Mr. Maleka is going to blame me for not answering straight.
Well, I will watch. So, yeah. Okay, thank you.
So that is the answer then, Chairperson, that as indicated in Roman figure 1 and Roman figure 2.
Yes, okay. Thank you, Mr. Maleka.
All right, Chair, let me try and follow that answer. And I hope that it is important for the Commission not simply to accept the answer because it's given, but to probe whether or not the answer makes meaningful sense in the light of the Commission's pursuit for the truth. Yeah. Now, Mr. Manyi, as I understand your answer, you say that the requirement is not singular in relation to the need for consent. You're suggesting that you may be transferred without your consent for as long as is in the public interest.
Yeah, that's my understanding of Roman figure 2, which did not apply to me. My specific situation which I here to respond to is Roman figure 1. The other provisions, I'm not the employer, and I can't speak for other people. I can only speak for myself. So myself, Roman figure 1 addresses my issue.
Thank you.
Thank you very much. I understand it. So on that premise, I'm willing to accept that if you don't consent, those who want to effect a lawful transfer as absent your consent, they must show that that lawful transfer is in the public interest. And Chair, I raise this question because you would recall that the transfer of Mr. Manyi was not without context. It was what we previously referred to as a cross transfer. It is in that context that we are exploring the issue. So these requirements will apply, but for now, Mr. Manyi, you would recall that your transfer took place in the context of the transfer of Mr. Masako out of the GCIS, because without the transfer of Mr. Masako out of the GCIS, you would not have been lawfully transferred to the GCIS as his replacement, correct?
Well, I'm not sure if that's fair, Mr. Maleka. You say you want him to say whether without the consent of Mr. Masako, his own transfer would have been lawful.
No, I'm not saying that, Chair.
Okay, what are you saying?
I'm saying that as a matter of fact,
yeah,
you could not have two heads of the GCIS.
Oh, okay. Well, if you put it that way, yes, that's fine. But that's not what I'd had.
Yes. No, I'm sorry, Chair. I apologize if I did not.
All right.
Mr. Manyi, I mean, it is fair to suggest to you that you cannot have the two heads of the GCIS at the same time, correct?
No, I mean, that's an obvious question. You can't, Chair, but I had provided cabinet statement. In that cabinet statement, in my initial response, I had provided a cabinet statement where these matters were dealt with. Cabinet noted that Mr. Masako is being transferred to DPSA. Cabinet noted that Mr. Manyi is going to replace Mr. Masako. So I'm not understanding this line of question.
Well, maybe let me ask this question. Prior to your being told that you were to be transferred to GCIS, were you aware whether Mr. Masako was to be transferred to another department?
Chairperson, that could never arise. I would never know.
Yes.
Yeah, there's no way that I would have ever known as to what is happening.
Yes. Well, of course, you could have known if Minister Chabane had spoken to you and told you what was to happen to what the arrangement was with Mr. Masako before telling you, or at the time of telling you that you would go to GCIS.
Yeah. No, Chairperson, Minister Chabane was a very honorable person. There was no way, and also meticulous in terms of his modus operandi on a whole range of issues. He's a very strict, disciplined person. And I accepted that when Minister Chabane came to say that there is this kind of an opportunity for me to go into this space, that they have taken care of everything else to enable that to happen. But it's not my call. And I think if I began to probe him, I would have been out of order. It would appear that I'm doubting his competence. No,
Mr. Manyi. You said that you could not have known.
Yeah.
And what I was saying to you is that you could have known if he had chosen to tell you more than what he told you. Do
Yes,
you
Chair.
accept that?
Okay, I accept that.
Yes, yeah.
But I don't think
in this case, you say he did not tell you.
And I don't think he had an obligation to tell me, Chair.
Yes. No, leave the obligation aside,
Okay.
just factually.
Okay.
He did not tell you.
No.
Yes. Okay.
And Mr. Manyi, at the level of fact, you knew at that point in time that Mr. Masako was the head of the GCIS. I mean, he was your colleague at the same employment rank, correct?
Yes, I did.
Yes. To get back to the requirements of paragraph D, you say that you consented to the transfer,
Yes.
and you seem to suggest that page 229 of Exhibit M1 manifests that consent. Is that your suggestion?
Two.
Page 229, Exhibit M1.
M1.
Yes, Chair.
Okay.
Yeah, that's confirmation.
No, I see that it is confirmation of your transfer, but there is not, as far as I read it, an indication that you have
I'm sorry,
consented.
Mr. Maleka, just raise your voice. I can't hear you.
My apologies, Chair. We are at page 229.
Yes.
The question is, I have looked at that letter, Chair, and I can assure you that I've read it more than once. I have not come across any indication in that letter that you consent to the transfer. Are you able to indicate to us, Mr. Manyi, what part of that letter the chairperson should read as an expression of your consent for the transfer?
Yeah, no, Chairperson, how the process works, that Mr. Maleka might not be aware of, is that the releasing minister and the receiving minister, they concur. And then there's something called a presidential minute that is put together. In that presidential minute, all the issues that is raising get contained in there to regularize the movements. So once the presidential minute is done, all those questions are contained in there. They're not contained in a letter that advises me that now you're going this way. So if Mr. Maleka is looking for that kind of an answer, he's looking at the wrong document. And the people that will hold that document will be the presidency. They will have the presidential, it's called the presidential minute. It will have that detail he's looking for.
Well, let me ask you this question. How did you convey your consent to the transfer? Was it verbal or was it in writing?
No, I think, like I said, Chair, that with the discussion, I agreed on the spot with the minister. And yeah.
In other words, your consent was verbal?
It was verbal, yes, Chair.
Thank you.
On that premise, Mr. Masako told the chairperson the context in which he was told by the late Minister Chabani how he would be moved out of the GCIS. And Chair, I'm not going to bore you with those details, but the key point of concern is this, that Mr. Manyi has now referred to a concurrence which is recorded in a cabinet document of some sort, as between the transferring and the receiving ministers. But you would recall that Mr. Masako said that he was told he'll go to the Department of, is it Public Administration?
Public Service Administration.
Yes, Public Service Administration. And his minister was not even too concerned about his presence there. And in fact, he had to leave at some point because the minister did not think that he wanted that DG. And that's the point of the inquiry.
Yes, well, I'm not sure, Mr. Manyi might be able to assist you with that. He has said that as far as his transfer was concerned from the Department of Labor to GCIS, he gave his consent verbally. And he has said, as I understand his evidence, he has said that when there is a transfer such as the one that took place, he understands that there would be a presidential minute where the issues that you are raising, which I assume include the issue of consent and maybe public interest, if that applies, would be dealt with.
Yes.
But I'm allowing you to
No, Chair, I think I will conclude that line of questioning on the note that, Mr. Manyi, as far as your discussion with Minister Chabane is concerned, it did not deal at all with the requirement for transfer on the grounds of public interest, correct?
No. And also, Chair, as it relates to Mr. Masako, I'm the wrong person to be asked.
Mr. Manyi, the next issue that I'd like to raise with you relates to your statement in response to Ms. Williams' testimony, especially that part of your statement where you challenged and criticized Ms. Williams' testimony about when you took over as the head of the GCIS. May I ask you in that regard, if you don't mind, to go to Exhibit M. And Chair, if you could turn to page 7 of Exhibit M.
Thank you.
And Mr. Manyi, you'll see that in paragraph 5.1, you say the 3rd of February was my first day as CEO, in brackets, Director General of GCIS, and as a cabinet spokesperson. The submission by Ms. Williams stating that Mr. Temba Masako left GCIS in January 2011 is false. You see that?
Yes.
And when you testified earlier on in your, I think it was the 14th of November, you went at length to criticize Ms. Williams about that part of his evidence. You remember that?
I was setting the record straight. Which say criticize, I don't know. I was not dealing with her, I was dealing with the facts. I just stated the facts as I know them.
Yes. I wonder whether you had an occasion to listen to Ms. Williams' entire testimony. You would recall that she testified over 2 days. You remember that?
Yes, I do.
She testified, Chair, on the 30th of August and resumed her evidence on the 3rd of September. And in fairness to Ms. Williams, on the 3rd of September, she was asked to clarify that part of the question, especially the date around which Mr. Masako left GCIS and Mr. Manyi took over. I can take you there, Mr. Manyi, if it's necessary. But I take that you had watched also the second day of Ms. Williams' testimony. Is that a fair assumption to make?
No, it's not a fair assumption. I didn't watch the second day.
All right.
I watched the 31st only when it related to the part that I needed to respond to. On
the second day, Ms. Williams corrected her testimony. Chair, we have asked your registrar to place before you the transcript of Ms. Williams' testimony on the 3rd of September. And for the record,
it is exhibit what?
it is not an exhibit, it's a transcript, Chair, of Ms. Williams' testimony. I can read it out to you. It's fairly straightforward and narrow.
Right. Yes.
And at page 20, Chair, opposite line 18, Ms. Williams clarifies her evidence as follows, and I quote, "Chairperson, I did go and verify the fact. It is true that the address by Mr. Masako and Mr. Manyi subsequently was on the 2nd of February, and I would concur with it." So, Mr. Manyi, if you're not aware, Ms. Williams has now corrected her testimony that it is true that you took over and Mr. Masako left around February 2011.
Around?
The 2nd of February 2011.
On the 3rd of February, Chair, is the date, not the 2nd.
Give or take. It's
Okay.
Now that you have that clarity by Ms. Williams, do you still criticize her as having given false testimony?
Can you raise your voice a bit, Chair? I can't hear him.
Yes, Mr. Maleka, raise your voice.
Now that you have that clarity by Ms. Williams about when you took over at GCIS, would you still criticize her as having given false testimony?
Yes, Chair, because the first was January, and now she continues to say 2nd of February. There's no give and take. The date is the 3rd. So even the 2nd correction is still wrong. It was on the 3rd.
Thank you.
The next issue I'd like to raise with you concerning your statement and criticism of Ms. Williams begins at page 23 of the same bundle.
Chair, can I just ask something quickly?
Yeah.
I know that this commission does not operate strictly according to court processes.
Yes.
But usually in court processes, when you have an affidavit that is from an applicant, then you get a response, then you get a reply. Now, it looks like Ms. Williams has submitted a reply affidavit, so to speak, but I was not provided this reply affidavit that talked to my issues. Now, Mr. Maleka is busy giving me all kinds of surprises now with information that was never provided.
Well, I don't know about another affidavit, but based on what he read out a few minutes ago, from what he was reading out from as the correction by Ms. Williams of an earlier evidence that she had given, he was reading from the transcript of the evidence that was recorded electronically in this commission when she gave evidence on the 3rd. In other words, as far as that one is concerned, he is not basing it on any affidavit. He's simply saying, if you go back to her evidence before this commission on the 3rd of September, as reflected in the transcript that he has, she did clarify.
Yes, Chair, the point I'm making, Chair, is that coming to this day, I had all the documents I had to consider. And now, if Mr. Maleka knew that this is also part of the documentation I needed to have in preparation for my responses here, I think I should have been given even that transcript if he was going to refer to it as it was, so that I don't, he's not the only one. Right now, even the transcript is reading, I don't even have a copy of it even as we speak.
Well, he is supposed to have made sure that there is a copy of the transcript in front of you. He has indicated that I was supposed to have it, I'm supposed to have it, but as you may have observed, he said he would just read it from what he had, and it's a small-ish, it's a small portion. So I don't think it's something that should really be very contentious. Did you have a copy of the transcript for the witness, Mr. Malega?
Yes, Chair. I asked the attorneys to place it before him. But secondly, Chair, lest there be a misunderstanding. In one of the letters where the Commission was sending to Mr. Manyi to prepare himself on this and other issues, he was expressly told about the testimony of Mr. Masako and Ms. Williams and the transcripts of that testimony and how he could get them and access them on the Commission's website. So it is not as if we're taking him by surprise.
Well, I'm not aware of anything that should make this a big issue.
Yes.
You say that you arrived at GCIS on the 3rd of February. She says she had initially given another date, I think in January. She then clarified and corrected herself and said, as I understand from what Mr. Malega has read, it was on the 2nd of February. Unless there is something that I've missed, I don't think it should really be a big issue whether it was the 2nd or the 3rd. You know, we can just move on.
Yes, Chair, I'd like to move on with your permission. Mr. Manyi, I am dealing with the second issue arising from your statement. It is at page 23. And you would recall that from that page, flowing to the next two other pages, you deal with the question of the text that you sent to Ms. Williams when she testified on the 30th of August. And as I recall your testimony, you accept that it is as a fact true that you send a text in the middle of a testimony. There is no debate in that regard, correct?
Yeah, no, there's no argument. If a chairperson during break is still in the middle of the testimony, which is when I sent it, yes.
Yes. Thank you.
Chair, all I want to establish are the few facts, and I don't want to enter into a debate.
Yeah.
I'm going to ask you some factual questions around that matter, which is common cause. When you sent that text to Ms. Williams, you were already aware and had received a notice from the Commission's attorney that Ms. Williams would be testifying from the 30th of August, correct?
Yes, that's correct.
And the notice told you of the rights you had, including your right to present your version under oath. You read that part of the notice, correct?
Yes.
And my recollection is that the notice was sent to you on the 17th of August. In other words, almost 13 days before Ms. Williams testified.
Yes.
And you would have been aware that at the right moment, you would be entitled to respond fully to Ms. Williams' evidence under oath.
Yeah, Chairperson, can I?
Yes.
Can I just say that yesterday, when I was explaining the circumstances of this matter. I alluded to the fact that I thought what I was trying to correct was actually did not even amount to a materiality thing in terms of what was happening, because all I was trying to do, I knew that I was coming to respond to the substantive issues, as it were. I didn't see this actually as a substantive issue, as it were. I just thought it's just something that, because also, Chair, as I explained, is that some of these mistakes in the rollout of the other people as they do things get picked up real time, and they've got serious damage that they cause to a person's reputation, which you don't recover 14 days later. So it's something that I thought needed to be corrected real time, and it was not material, and it was factual. That when you mentioned the name of Mr. Zweli Momeka, he came in 2013. So I thought she would actually have appreciated that. I was not trying to distort or do anything, but just to make sure that as she does her things here, it must just be within the right time frames. That's all.
Thank you.
Last question on this, Chair. Mr. Manyi, my difficulty is this. By the time Mrs. Williams gives testimony and you feel compelled to correct her, or you feel compelled that he should say something more about that testimony, on your version, he had already committed a critical mistake you identify as false about when you started as the head of the GCIS. So on your approach, that was not the first mistake or false statement she mentioned in her oral testimony. Why did you not consider to correct her by SMS when she committed the first mistake, when the second mistake you describe as not being material? Is there any reason why you did not choose to correct her by SMS?
Yeah, no, Chairperson, I was told how the process works, that I'm going to have the opportunity to respond substantively. And I was actually given the affidavit beforehand. So I knew the areas of contention. And the reason I didn't respond to those areas of contention is because I was going to get the opportunity to respond to them properly. This arises out of oral evidence. And even there, it was actually, in my view, I do say that, I did say in my affidavit that what happened is that I did say that the evidence leader was patently clear with the areas that she was probing, which was paragraph 14 to 16 of Ms. Phumla Williams's affidavit. She was done with it. She was moving on to paragraph 17 on other matters. And once she was there, then she began to ask about what other changes were there. So that was a change. That was something that even in the correspondence from the commission was not a matter that I was seized with. It was a developing matter, and it developed out of pure accident, if you like, which I thought I can just resolve.
Well, Mr. Maleka,
yes,
I'm not sure whether you have in mind that you would suggest that the explanation that Mr. Manyi has given for sending that text message to Ms. Williams while she was giving evidence is false, or that he was actually trying to get Ms. Williams to give untrue evidence, because if that's not the intention, I'm not sure that the time that we have shouldn't be used for other areas that may be more important. I can just say that at this stage, subject to what you or the legal team of the Commission may say, my prima facie view is that the explanation that Mr. Manyi has given is acceptable. And unless, obviously, if you later on wish to persuade me differently, I would look at that. But it seems to me that it's something that we shouldn't spend too much time on.
Yes, Chair. I asked these questions because you asked us to probe this question. Secondly, yes. I raised this issue because you... No, you are right, yeah. You are right. I had asked, that was, I think, of course, before I read his explanation. Yes. And after I read his explanation and had his evidence, I didn't convey anything to you. But Chair, I must conclude on this because there are other important matters to deal with. But I ask this in order to protect the integrity of the Commission's processes. Yes, okay. No, that's fine. So that all and sundry must understand that it is inappropriate to interrupt witnesses' evidence, especially when they have received notices that where they're implicated, they will have a proper opportunity to set out their full version in response. Can I move on, Chair? Yes, you may move on. Mr. Manyi, the next topic that I'd like to raise with you, and again I do so in the interest of trying to establish the truth, is your response to Ms. Williams' version when you characterized the evidence as a corrupt empire equivalent to the VBS, which you had to dismantle. You recall that?
Yes, I do.
I'd like to establish some facts, Chair. And I'm not going to go into a debate about whether Mr. Manyi's description is correct or not. All I want to do is to establish the facts. Mr. Manyi, as I understand, and from the investigation that the Commission's investigators had conducted, when you came in as the head of the GCIS, you reappointed Ms. Williams as and to continue as the head of or the chairperson of the bid adjudication committee, correct?
Yeah, that's correct.
And by that time, when you appointed her to continue, you had been aware of the Treasury report around allegations of improper procurement of the 3 companies that you had identified with reference to Stats SA procurement, correct?
Incorrect, Chair. The report of National Treasury came 1st of November 2012. I left the department 25th August 2012. So it's not correct.
So when did you come to the conclusion that you have inherited this mini VBS bank?
The reason we instituted the reason we instituted an investigation, Chair, is because we had prima facie evidence of a malfeasance of sorts. And this is why we got the investigation going. Now, why is the investigation going? Because we are rule of law people. You have to presume people innocent until proven guilty, and so on. So I didn't presume anybody guilty, so to speak. But at the same time, I had to do some precautionary measures, as it were, to make sure that we root out the malfeasance that was patently clear, but we also needed to get proper confirmation from a proper investigation.
When did you come to the conclusion that you have inherited a VBS type of an operation?
In 2011 sometime, I don't remember the date.
You can't give us a date that we can work on, a month, even if it's an estimation.
I can't give the date. I think the time when the change was made to dismantle, around that period, that is when I had sufficient information to say we can't continue like this. I gave the process a chance, and we've been asking people, even our own internal investigations, by the way, they did also ensue and all that. So whilst we were waiting for formal reports from National Treasury and elsewhere, but we also did our own little probing just to understand what was happening. So it must have been maybe then at the end of that process, maybe towards the end of the year, that one was sufficiently informed to say, we have to change this.
Mr. Manyi, shall we proceed on the premise that when you decided to dismantle the bid adjudication committee, you then took out Ms. Williams and she no longer chaired that committee. You appointed a new chairperson, correct?
Yes, and 4 members. It was 4 people that were removed and replaced.
In the bundle that we gave to you to prepare yourself, we included National Treasury's directive on a lawful composition of the bid adjudication committee of an entity such as the GCIS. I take it that you have read the directive. I take it that you knew it even before we enclosed it in the documentation handed to you. Chair, is on page 14 of Exhibit M1.
Thank you.
So if you're there, Mr. Manyi, and this is National Treasury speaking, it's not me or the investigating team or the Commission. In paragraph 8.1, the directive requires the following. The Departmental Bid Adjudication Committee will comprise of members appointed by the accounting officer or his or her delegate through the acquisition policy and delegations. So the directive requires that you should establish a bid adjudication committee as the accounting officer. But then it says the following. The composition of the committee will be as follows. Chairperson, DCO.CS. And it is common cause that Ms. Williams was occupying that office of DCEO at the time when you took her out of that bid adjudication committee, correct?
Yeah.
So when you reconstituted the bid adjudication committee, you would have acted inconsistent with this directive when you excluded her from not only being a member, but also the chair of that committee, correct?
No, incorrect. I think Chairperson, this is a simplistic approach that is taken. Also, this page I have here, this page 14, it would have been good to have seen the cover page of this. It has nothing even here that says directive. I'm not really sure what I'm looking at, but be that as it may, the accounting office, the duties of the accounting office are clearly spelled out in Section 38 of the PFMA. Now, if in my view, whatever arrangement I found, which might have followed a particular guideline, I found that not to be achieving the purpose it was intended for, nothing stops me to rearrange it in a manner that is going to deliver the objectives of the PFMA. So the changes that I brought in restructuring this committee, they did not flout a regulation. They did not flout a law. It could have been not in line with a particular guideline of sorts, but guideline is not a regulation. It guides you, but if you have something better, you can improve on a guideline. It's a guideline. You don't have, you're not fixed on it. It's not a law.
Chair, we will leave the rest for argument. The provisions of that directive are clear to me. I won't pursue the issue. I think I have established such facts as I need to later make arguments on these matters. Mr. Manyi, the next issue that we would like to raise with you, and you must tell us whether you are comfortable in dealing with it, relates to the investigation that the Commission's investigators had done. And that investigation revealed that you received 2 CVs of persons. And Chair, we have placed those CVs before you. We have redacted the names of the persons concerned so that there ought not to be an unkind disclosure of their details. We can assure you, Chair, that before we thought we should raise these issues, we did write to the person concerned about this matter and afforded them an opportunity to be present or exercise whatever rights they have in terms of the rules. So on that premise, Mr. Manyi, can I proceed and ask you some matters of fact in relation to the CVs concerned? My understanding of your evidence up to this point is that you claim that it would be inappropriate for us to ask questions about those CVs because you received them when you were a private person and not an employee of government, and that there's nothing wrong for you to receive CVs from other private persons. Is that a first summary of what you have said thus far concerning the CVs?
It's a half summary, the full summary, Chairperson.
Oh, before you give the other half of the summary, Mr. Maleka, where are you now?
Chair, I am at M1,
yeah.
Page 58.
Yes, thank you. Yes, Mr. Manyi.
Yeah. Because firstly, I had asked a clarity-seeking question before we deal with the emails, because this is an email story. I needed to know, Chairperson, as to what brings private conversations of people that are both not in government, private sector people sending around emails to each other.
Yeah, yes, Mr. Manyi, I think what you are raising is a question of relevance. Yeah. You are saying, why is this relevant to what the Commission is doing? And Mr. Maleka will address that.
Yes. Chair, if I may address the question of relevance at 2 levels. You will see, let's start with the first CV at page 58, that it is distributed as between 2 persons. The first, of course, is the original message from Mr. Manyi, dated 5 September 2014.
Sorry, page?
580.
580, okay.
And the recipient, Chair, of that electronic message is someone called Ashu, and the email address is ashu@sahara.co.za, and the subject matter is identified as a black woman legal, and I'd like to explore without raising it for now. the content of the email. That's the first part of the relevance answer. But the second and more important part of the relevance answer is the CV is addressed to someone and it records the discussion with another person of the Gupta family. Your mandate requires you to interrogate the way they ran business and whether the way they ran business engages their involvement in acts of state capture. You will receive evidence about one of the modules on how they ran business by receiving CVs of so many people, including allegations that some of them come from members of the executives. We want to understand the role of Mr. Manyi to that extent, if he has any information that he can help you in that regard.
Okay. You heard that, Mr. Manyi?
Yeah, okay. Although it's not clear as to what this means, but I said, okay.
Yeah, maybe if it's fine with you, let me allow Mr. Maleka to ask some questions. Maybe from the questions, the relevance might become clearer.
Yeah.
And then if you still have a problem later on, you can raise the issue again.
Yes, and then when it does so, Chair, if you can then also point out the irregularity of the issue.
Well, it might not be an irregularity, but I think what you are, you are going back to the issue of relevance, because you say it would be the irregularity that you understand may show relevance.
Yeah.
Okay. Mr. Maleka.
Thank you, Chair. Mr. Manyi, on the face of this electronic message, you have annexed a CV of a black woman and sent it to Mr. Ashu, and I take it that is Mr. Ashu Chawla, correct?
Yeah, it is.
And it is quite clear on the body of the email that you tell Mr. Chawla, as you transmit this electronic message, including the CV, that you are sending it to him, and I quote, as discussed with Tony. Correct?
Yes, Chair, I'm still confused though.
I just want to establish the facts. We'll come to whether or not.
I did say yes.
Yes.
Yeah, he said yes.
Thank you, Chair. And the Tony referred to in that email, who you discussed with, is Mr. Tony Gupta, correct?
Yes.
And Mr. Chawla, Mr. Ashu, that you have sent this CV to at the Sahara email address was connected to the Gupta family, correct?
Yes, but I still don't understand what turns on all of that.
Mr. Manyi, the sum total of the questions and answers which we have explored thus far suggests that you have taken
Yes.
And you see that the original message from that page comes from your email, correct?
Yes.
It is dated 26 November 2014, and you address this to Mr. Nazim Hoa, correct?
Yes.
Do you want to tell the chairperson who was Nazim Hoa at that point in time and his relationship with the Gupta family?
No, Nazim was the, I think, Group CEO of Oakbay.
Of Oakbay.
Yes.
And Oakbay is the holding company which was owned by the Gupta family.
Yes, public knowledge.
Yes. And to be quick, the body of the CV encloses a second CV of another person in the field of IT, correct?
No, incorrect. This is not a CV. This is a business proposal.
It's a business proposal.
Yes.
Thank you for that correction. I misread it, and my apologies. So you enclose a business proposal addressed to Mr. Hoa of another person, correct?
Yes.
And so what is the context? Did this person ask you to introduce this business proposal to Mr. Hoa? Or did you take it upon yourself simply to introduce the proposal to him?
So this is the thing, Chair. I just want to understand what is the business of this commission in this issue?
Well, Mr. Maleka has indicated when the issue of the relevance was raised that part of the terms of reference is to look at state capture and allegations involving relating to state capture and other acts of corruption relating to the Gupta family and to other people. And he has indicated that he is looking at the way they may have been operating. But maybe what I could say in order to try and assist you, Mr. Manyi. Mr. Maleka, do you want to try and go to the head of your line of questioning? Yeah, because I think a lot of it is about the background or establish certain facts, and you are entitled to do so. Yes. But you might have a way of expediting reaching the real point.
Chair, I've explored all the factual matters I needed.
Yeah.
And I'd like to move on, if you don't mind.
Okay, all right. Thank you.
Mr. Manyi, the next, or the second last topic that I'd like to raise with you relates to the High Court application that you made for the liquidation of Afrotone after you took over the Gupta family's media businesses. You recall that in the bundle that we gave you, we included the copy of the court papers, which include the affidavit that you made. And I take it that you read that application for the purposes of our discussion, correct?
Well, the first correction I need to make, Chair, it was not for the liquidation of Afrotone, as Mr. Maleka is saying. It was for the liquidation of TNA.
Yes,
but I have the document.
But you have read, you did read it. I'm sorry, did you give an answer to that, Mr. Manyi? Did you give an answer to the question whether in preparation for this hearing you did read the application?
I put the application myself, Chairperson. Yeah, I did.
You read it?
It was my application.
Thank you.
Chair, first thing first, before we explore the idea that I'm incorrect, Can I ask you to go to page 79 of M1?
Yes.
In fact, the document starts at page 78. Do you see that?
Yes.
And the applicant, who is described as the first applicant in those proceedings, is Afrotone Media Holdings. Correct?
Yes, that's the applicant.
And if you go to your own affidavit on page 85.
Page?
85.
85.
In paragraph 2.1, you under oath describe who the applicant is. You say, I quote, the first applicant is Afrotone Media Holdings, a private company with limited liability, and the rest is there. So it was the applicant in this case.
I think there's a miscommunication here, Chair. I was not querying who's the applicant. I was querying who was being liquidated.
Yeah.
We'll come to that point because you explain who is going to be liquidated and so on. But for now, Mr. Manyi, if you don't mind, if you go to page 79, in paragraph 2, this is a legal document called the Notice of Motion. You say that you ask the court to liquidate the respondent, and it must be placed under provisional liquidation. You see that?
Yeah.
And the respondent is TNA Media. Do you see that?
Yes.
So it is Afrotone which is going to court to liquidate TNA Media.
Yes.
What I want to establish from you is this, and I'm sure you would know the difference between liquidation of an entity and business rescue of an entity, correct? I mean, you're a businessman, you know the difference between the two, correct?
Yeah, correct.
And so when you instituted this application, it must have been clear to you and your fellow directors that the business of TNA was beyond any business rescue and therefore had to be folded over by way of a liquidation, correct?
Yeah, that's factually correct.
So there was no way that this business is going to be saved. It had to fall over. Now, the question is this. That provisional order you requested, I take it that it was granted.
Yes, Chair, it was granted.
It was provisional, and therefore lawyers would go back to court to debate whether or not that provisional order should be made final. What is the status of that provisional order?
It's been finalized, Chair. In fact, tomorrow it's the auction.
Yes.
Mm-hmm. Thank you.
Thank you for that clarification. So after tomorrow and after the auction, Afrotone will not have a business called TNA Media, correct?
Yes, that's correct.
Yes. What I want to establish now that we have the facts from you is this. It must have been clear to you, Mr. Manyi, when you took over this business in August 2017, that it was a loss-making business. There was no way it could be saved.
Well, that is an incorrect summary. People buy loss-making institutions with a view to turning them around. That was the situation. And the fact that it was a loss-making it's actually recorded in this affidavit. So it's acknowledged that it was a loss-making. I came into this with my eyes open. But in this affidavit, it's detailed how we thought we were going to turn the situation around.
Mr. Manyi, we can do it the long way or we can do the short way. But I can tell you that I have looked at the financial statements which we have included in this bundle of TNA, especially for the relevant period when you bought it in 2017. It was quite clear when you consider the financial statements of that entity, that it was in a loss-making environment.
Yeah, but Chair, I repeat that there is nothing sinister
yes,
about
Mr.
buying
Manyi,
a loss-making business.
You did make that. He did make that point, Mr. Maleka. He says you, as a business person, you might look at a loss-making business and say, well, I have an idea how to turn it around. The people who are running it don't know how to turn it around. I will turn it around.
Yes.
That's what he has said.
Yes. And Chair, if I can, with your leave, I want to explore that to show that it was quite clear on his approach that you could not even turn around this business. Do I have your permission to explore that issue?
But what will be the point? What's the point for purposes of the commission? You know, let's assume his what he had in mind, which he thought would work, just was something that could never work. Let's assume that. How does it help us in terms of the Commission's investigation?
Chair, the record will show that we have sought to indicate to you right from the beginning, when we examined the element of state capture relating to TNA business of the Gupta family. The record will show that they sought to obtain business by methods that were inconsistent with the law. The record will show that we suggested to you and have led some evidence to some extent that without government support, this business would not stand. We want to round up and dot that part of what we said to you on the record, that it was quite clear that without government business, this entity would not survive, absent those elements.
Well, you might be needing to put a certain question to him, maybe relating to the basis upon which he thought he could turn it around. I'm not sure, but
I will move on, Chair.
Okay, yes. Move on. Thanks.
Mr. Manyi, the last topic that I would like to address with you is the one that we have talked about yesterday. And I just want to clarify some aspects of it, because you talked in general terms, and I want to make sure that I understand that when you are not here and we debate the argument before the chairperson, we are not confused about what you meant in your general description. One of the issues raised was that government felt excited by seeing this new player called TNA to come into the media space and compete with the cabal. You remember that?
Yeah, I do.
And I want to understand who in government would have been so happy in the context of the discussions we have had around GCIS procurement of media buying on behalf of the government, on behalf of the state.
Yeah, no, Chairperson, I served in a forum called FOSAT. This is a forum for DGs. So this is a place where we discuss as DGs various policy coordination matters and so on. This would have been a place where one would have, as part of my input into that forum, to say, by the way, there's a new player on the block. That as we do what we do, let's consider also in line with the government strategy of media diversity and all that, let's consider doing business with this kind of a player because they've got these innovative strategies and so on. So I would have done, call it a sell job of sorts to my colleagues. And all of that. And yeah, that's the level I operate. So I would have spoken to fellow DGs. I would have spoken to, we also had a forum called communications, some communication meeting where all the communicators would meet regularly. I would even table there that there's a new player on the block let's consider doing business with them. So it's quite an above-board matter and so on. So,
Thank you.
And that sale type of process would also have taken place in GCIS. You'd have told GCIS that there's a new player.
GCIS has got, keep repeating this, has got tools how they do their work. It is everything that must happen within a particular process, as it were. So there's nothing that, as a result of the sale, happened irregularly. And Chair, I think the record of GCIS would show that as far as interacting with TNA in particular, now that is Mr. Maleka's bone of contention, there was nothing irregular with the interaction of GCIS with TNA at any stage, at least while I was there.
Chair, I'm not going to go through the details. You've heard the evidence of Ms. Williams, who told you about Tilma, and that Tilma could not recognize TNA's breakfast show, and that there was an issue around it. For now, Mr. Manyi, can I confirm the facts?
Can I interject, Chair?
Yes.
I think it's important to understand what is Tilma, and it's important to understand how GCIS operates. If anybody, Ms. Williams included, thought that Tilma is a be-all and end-all of how GCIS thinks, that understanding must be dismissed, Chair, as very incorrect and very lacking in a strategic substance, as it were. There's no such a thing. Tilma, Chairperson, for just a quick workshop, Tilma is a software that places adverts and so on, but that does not take away other platforms, other approaches or platforms or opportunities to ensure that you get the exposure that you're looking for. To place an advert is one way of communicating what you want to communicate. But you can also do it differently. You don't have to place an advert. You can go on TV and do something different. So, and TV and that approach that you do in a particular platform does not have to have been dictated to by Tilma. I did say yesterday, it's just one of the tools. It's not the only tool.
Thank you.
Chair, can I ask you to make this for your notes, because Ms. Williams went at length to describe not only Tilma as an evaluation tool to procure media buying, but also the legal basis of it, that they had to go to Treasury, they had to get a special dispensation under Treasury Regulation 16.4.A, which we now know. You will find all of that evidence.
I think you must tell the witness that basis, yes, to give him an opportunity to say, but that's wrong if it's wrong.
Yes.
Because as I understand it, your position would be that Tilma was legally obligatory.
Yes.
And he is saying that was not so. So it's important that you put to him the basis so that he can deal with it.
Ms. Williams says these things at various places, but for now, Mr. Manyi, I have asked the attorney of the Commission to place before you the transcript of her evidence of 31st August 2018. It is titled Day 8. Do you have it?
No, where's that?
I'll ask one of my colleagues to help you locate it.
Day 8.
Day 8. Chair, I'll read it for you so that...
I don't need to look at it?
Not at all.
Okay.
This is M1. This is M1. But Chairperson, as we're still shuffling through paper here, I want to place it on record.
Yes.
That is not true, that Tilma is in any law. There's no such a thing.
No, hang on, Mr. Manyi. You had made that point.
Yeah.
I was giving Mr. Maleka an opportunity of telling you what the basis is or is for him to suggest that you are not correct.
Okay.
So I want you to hear his basis and then deal with it.
All right.
Chair, at page 39 for your records, page 39 of the 31st August 2018 transcript, Ms. Williams says the following, and I read it for you so that we are together on this. Ms. Hofmeyer asked her the following question. It's opposite line 16, give or take. So to understand the context in which this occurred, Ms. Williams, you make reference to the...
Sorry, Chair. I haven't got the actual page here. Where is this?
Oh, okay.
39.
39 of the bundle that was put to you by the attorney or counsel who was assisting you. Well, just check, Mr. Maleka, whether you have the same document on the page.
I believe that he has it, Mr. Chair.
Oh, okay, all right.
But the part that you are reading, I don't see it here.
Page 38, are you at page 38?
Maybe tell him what is prominent on that page.
Yes, you will see that on the left-hand side of the pages, there is a marginal number. The prominent one there is number 10. Do you see that?
Yeah, you see, Chair, my number 10 is blank. Is that the one?
No. I'll ask my colleague, Ms. Molefe, to go and identify for
otherwise, we...
Okay, so to understand. It's page 39, so to understand. Line 14.
I assume, Mr. Maleka, that it's important to have a look at it. Otherwise, if you know the point, you could put the point. Maybe you might be able to answer it without looking at the transcript.
Ms. Molefe, it is the transcript of 31st August 2018. Are you at page 39? And if you go to the middle, do you see line 10? You'll see.
Maybe what should happen, I think you take that, go to Mr. Maleka, let him show you the correct page and exactly where he wants to focus on, and then take it to the witness.
No, but this is, mine doesn't have Pretorius. No. Are you sure?
Yeah, this is KM.
I'm glad it's not that straightforward.
Sorry, Mr. Manyi?
So I'm glad it's not that straightforward, Chair.
Well, maybe, Mr. Maleka, will take a 5 minutes adjournment to get this sorted out.
Yes,
so
Chair.
that
There must be some confusion about the transcript. Because mine is page 39 of 113. The one place before Mr. Manyi is page 39 of 117. So,
is it possible to either put the point to him on the basis that he might be able to answer even if he hasn't looked?
Yes.
Or that you move to another point and then later on maybe one of your colleagues can look at the issue of different pages and later on you can go back to it, depending on how important it is.
I can do the first and it will be quick, Chair, if I may read.
Yeah.
The question by Ms. Hofmeyer is the following. So to understand the context in which this occurred, Ms. Williams, you make reference to the Tilma system, which relates to media buying. Can you tell us a bit more about how that system works? Question mark. Ms. Williams answers as follows. Chairperson, I can have some water. I think my throat Question. Chairperson, I indicated earlier that when we agreed with National Treasury that we would like to bring it in-house.
Hang on, you're going to confuse the witness. Just hold on. Let's see how this works.
I indicated earlier that when we agreed with National Treasury that we would like to bring it in-house, there was an acknowledgement that we can use a delegation 16 in bracket A 6.4, which essentially, it's a delegation that is given to departments if it's something that is beyond our control, which you need to do. However, the issue there is that you can use it, but you must write a motivation why you think this medium is the correct one, whether it is cost effective and whether it will get to those audience that you want. Now, our understanding is that the Tilma was assisting us to do that. A briefing from a client, load that in the briefing into the system, and the system would then say this is the most cost effective and effective in terms of the audience that you want. And the media buying people had to write down and submit it to us. Now, in the case of TNA, we battled with how do we load?
Mr. Maraga, that's going to be too long for the witness to remember. I thought you were going to just put the point to him and see if he's able to answer it without looking at the transcript. He might not be able to.
The essence of it is this, Chair.
Yeah.
That Ms. Williams has confirmed under oath that Tilma was a delegation that was obtained from National Treasury. Secondly, that they battled in applying Tilma to TNA because Tilma could not identify the breakfast shows relating to TNA. And that's
were you not looking for the basis upon which you were to pursue the point that Tilma was obligatory?
Yes.
Because Mr. Manyi said it was a guideline, if I understood correctly, and you said that there would be references which show that it was legally obligatory. So I thought you were looking for something that you would put to him to say, look at this. This suggests it was obligatory, and he would then comment on that.
Yes. Let me do that, Chair. I have read that part of Ms. Williams' evidence on how National Treasury gave them the delegation. I can put some few questions, if it is convenient to you and Mr. Manyi, on that issue.
Well, would that resolve what we are looking at? Namely,
yes.
Would it show, as far as least as you are concerned, that Tilma was legally obligatory?
Indeed.
Okay, go ahead.
I believe that my colleagues have found it now.
Okay. But if there is a way of doing the short route without reading that long passage, that would help.
Yes. Mr. Manyi, as I understand, government cannot go into public procurement without following the rules of procurement. And as you have said, the basic rule is competitive procurement in terms of Section 217 of the Constitution, correct?
Can you repeat the question?
Government has no right to go and procure goods willy-nilly. It must follow a system of procurement. And the basic rules of public procurement are set out in Section 217. In other words, GCIS cannot wake up and say that it's going to go into media buying without following a public procurement process. Are we agreed on that score?
Okay, can I clarify this, Chair? because I think there's a confusion and conflation of issues. The bulk buying, which I suspect is what Ms. Williams was trying to explain here. Tilma is one of the tools within bulk buying. So the issue that exemption was sought was an issue of a broader subject of bulk buying.
May I suggest that you deal with the question, you consider dealing with the question in this way? To his question, yes, it is so, or no, it is not so, or yes, it is so, but with a qualification. Under the following circumstances, this can happen. Under different circumstances, it can't happen.
Okay,
are you comfortable with that?
Yes, correct.
Yes.
The answer is no, because there are certain circumstances which the public process cannot happen. It's just not practical if you're doing media bulk buying
Yes.
to go a different route than what was being exempted.
Yes.
So what was exempted here was a bulk buying as opposed to Tilma. There's no such a thing as Tilma in the regulations.
Mr. Manyi, you may be correct or not, but the simple question is this. GCIS could not go out to the market and do bulk buying of its own accord without following some system of public procurement. Are we agreed on that score?
Chair, I'm confused by this question because I thought I've responded to it. And the response is that there are two ways of procuring. It's public procurement, where you issue tenders or whatever to say who can do this, or it's the media bulk buying approach. In that approach, you don't go and advertise or anything. It's a different approach that's being used. This is why, for bulk buying, you get an exemption of how to do it, because it's not practical, because, yeah.
But when you get exemption, that is still under procurement rules, as it were, isn't it?
Okay,
now,
that's
exemption is provided for in the procurement rules.
Yes, Chair.
Yeah. So in other words, your answer would be even when you have got exemption, you are still acting in accordance with the procurement rules because the procurement rules make provision for that exemption. Am I correct?
No, Chair.
Yeah.
The exemption is to exempt you from the day-to-day procurement rules.
Yes, but the exemption is not in the procurement legislative framework.
Yeah, it is, Chair.
In other words,
yes.
If you look at what you would consider to be legislative framework,
Yes.
there is a general rule to say, if you want to procure, this is the general rule.
Mm-hmm.
But there are exceptions to it. Mm-hmm. And these are the exceptions. And one of the exceptions is maybe you don't need to do A, B, C, D if you have received exemption. And exemption can be provided under the following circumstances.
The confusion that Mr. Maleka brings in that discussion, Chair, is that he then talks to Section 217, which talks to things that are like cost effectiveness and fairness and competitiveness and all of that. The exemption seeks to get away from that. People that are appointed on exemption could be challenged on competitiveness, could be challenged on a whole manner of ways, but you would have been exempted lawfully from it. But now the impression I'm getting is that having been exempted, so to speak, when you do whatever on an exemption, I'm getting the sense that you would perceive that as having flouted Section 217. And because it keeps on saying, in terms of Section 217, exemption is outside 217 because it's when you can't do 217.
Yes, no, that's fine.
Chair, I can put broad proposition and he can comment and we'll move on.
Yes.
Mr. Manyi, media bulk buying is still public procurement by GCIS. It is not private procurement. Do you accept that it is still part and parcel of public procurement? I
accept that it's an exemption. Chair, this is the thing. it's an exemption of 217. So
I want to put another broad proposition. Because we now agree that media buying is part and parcel of public procurement by GCIS, the exemption that Ms. William talks about and that you now embrace, it is from a method of procurement, not from the nature of the procurement. In other words, you may not follow the normal open tender process. You follow the procurement process via Tilma. So Tilma, it is still a method of public procurement.
no, this is a problem, Chair, because in terms of Mr. Maleka or Ms. Pumla Williams' articulations, is that the only way passport into procurement in the exemption is only Tilma, and I'm saying that's not true. That the bulk buying that it encompasses Tilma and also other considerations, as it were. It's not just Tilma and Tilma only.
Yeah.
For instance, community media, Chair, as I made this point yesterday, is not in Tilma, but you will still procure from community media, which is not in Tilma. That will still be public procurement.
Thank you.
Chair, last point, and that will be...
And how far are we from?
I'm almost done, Chair.
Okay, all right.
Mr. Manyi, we confirmed yesterday that TNA did not use the ABC type of verification in order to prove the extent of its circulation. We have gone past that issue, correct?
Yes, spoke to that.
And you said that TNA, to verify its own circulation figures, would submit figures from the auditors, correct?
Yes.
Just as a matter of practicality, how does it go about if Mr. Lupo, who we know was the head of media buying in GCIS, would say, I'd like to use TNA here? What does it do as a matter of practicality? Does it call for the audited figures?
Can you just rephrase the question? I'm not understanding your question.
Mr. Lupo was in charge of the media buying, correct?
Yes.
And he was reporting to you?
Yes.
Directly?
Yeah.
Did he report to you how he would assess the circulation figures of TNA to justify its appointment for media buying?
Okay, Chairperson, I think the first point that must be, the answer is no. But here's the issue. Tilma, if anything, is actually not a circulation tool. It's actually a readership tool. When you formulate what goes into Tilma, the system itself, how they do it, Chairperson, just so that Mr. Maleka is clear. Tilma sends out some kind of a spreadsheet with the various titles of all the newspapers. They go around asking you, which newspaper do you read? You say, I read The Star, I read New Age. How old are you? What is your level of education and all that? They format that into, in conjunction with the Stats SA information about household and all of that. And then when you are a front-end user of Tilma, what you put into the system, you then put in the LSMs that you're looking for, you put in the geographic area that you're looking for, and that gives you people that read that kind of newspaper in the area. It doesn't talk to circulation, talks to actually, it's a readership thing more than a circulation thing. So the conception that Tilma and circulation and this is totally wrong. Tilma, for all intents and purposes, is a tool that tells you who reads whatever kind of publication and so on. And if you're looking for this kind of LSM, this kind of age, this kind of education, those kinds of people tend to read business day kind of thing. So that's all it tells you. And then you go from there.
Thank you.
Chair, I would not pursue that issue. Can I, in conclusion, place on record that to the extent that Mr. Manyi has raised issues in his last set of affidavits relating to allegations of state capture by National Treasury with reference to that procurement of 1.7 billion, we as the legal team are certainly interested in pursuing that issue, and we have referred the allegations to National Treasury for it to comment. And at the right time, at the right moment, resources permitting, we will ask for Mr. Manyi to help us in that regard. That ends my questions to Mr. Manyi.
Thank you, Mr. Maleka. There is just one issue that I would like you to clarify, Mr. Manyi. Earlier on this morning, you sought to provide clarification as to why, I think, using City Press to compare the revenue that it got from GCIS for advertisements compared to the New Age might not give a good picture.
Yes.
I think what you were saying was City Press, what we see in the table that you provided would not be everything in terms of revenue that City Press got during the relevant period.
Correct, Chair.
Did I understand you correctly?
100%, Chair.
Yes. Do you know how much else they might have got, that is City Press? I'm simply asking because you are the one who brought the information to us. You might or might not know.
Yeah. It's not broken down, Chair, but on that Ads 24, it's lumped in there. So GCIS can be asked to provide a breakdown of that number. But because right now I've got a global number of Ads 24, which is an Asper's thing, and as I said yesterday, City Press is there. So the actual breakdown as to what is in that global figure, GCIS is in a better place to do this. I don't know it offhand.
Okay. So you don't know what the figure is?
No, Chair. I just have the figure that is, what is tabled here is what went into the NASPERS group, as it were, the Navusa group, as it were, or Tiso Black Star, as it's now called. I've got those global amounts. But as I said, we've got some ad hocs of both these groups that are there, and they give a distorted figure as if that 200,000 or 30,000 is all they got. That's not true. There are still those various publications that are double dipping, if you like. They have got their line items as themselves on ad hoc basis, but they are also in the big amounts of their marketing wings that are Ads 24 and the other one.
Well, I would say that that information may be important and maybe beyond today. You might wish to be in touch with the legal team, because if documentation that GCIS has may back you up on that, it might be important to have a look at, because it relates to one of the most important issues, I think, in terms of your evidence. Namely, if one looks at the revenue that the New Age made from GCIS for advertisement during the relevant period, it's far greater than certain individual publications. Now, you have testified as to why you think that may be justified. I did hear that. But what you have just said might be quite something that one can look at and to see how much, whether it closes the gap or not, because it may well be that whatever it is that must be added onto the city press revenue for that period still leaves quite a big difference between what city press got and what the New Age got. But it may well be that it makes a substantial difference, so that the gap is narrowed quite significantly. So I'm just mentioning that I am interested in the exploration of that part of your evidence, and you might be able to assist if you are in touch with the legal team beyond today, so that we get that information if possible.
Except that, Chair, and this is a point I tried yesterday to make, that is not a linear relationship. I'm not sure I can get that information. But if the frame of reference is one of a linear relationship, then that information will not assist. In that, if the contention of the Commission is that purely based on your circulation, therefore, there's proportionately more revenue you should be getting, then that is an incorrect approach, because in the execution of the duties at GCIS, we looked at more than that, because there's, as I explained yesterday, that there's issue of target marketing, as it. But I can give the figure, but it's not. I can give that breakdown.
Yes.
But I just want beforehand to warn the Commission that it's not a linear relationship.
No. I understand you, Mr. Manyi. That's the point you made even yesterday.
Yeah.
And it's a point you made even today.
Yeah.
So I understand it.
Okay.
All I'm simply saying is there is a piece of evidence that you have given, which I think may be important, that I would like to be explored. And I'm simply thinking that the legal team on their own, without your assistance, might not be able to say what to ask for from GCIS, but with your cooperation, that might be easy to find.
All right, Chair.
Okay.
For sure.
Thank you.
Thank you, Chair.
Thank you very much. We thank you for having come to give evidence to the Commission. You may or may not be asked later on to come back, I'm not sure, but thank you very, very much. You are excused for now.
Thank you, Chair.
Thank you. Well, Mr. Malega,
yes.
I think that we probably should take an adjournment before, a short adjournment before we start with the next witness.
Yeah, Chair, we started early, so if it's convenient, we can start. We can take, it's 12:30 now, we can take a short lunch adjournment for 30 minutes and resume at 1 until Mr. Mukwena finishes.
Well, as far as I know, the next witness shouldn't take too long. If I look at his statement, which I've read.
Perhaps Mr. Mukwena should address you on this issue.
He is refusing.
Mr. Chair, I refuse to estimate, having regard to the experiences of the previous witnesses, and also when we attempted our best to give proper time allocations, we have failed dismally. So the statement might be short, but the witness might not be as short as the statement.
Yeah. Okay. No, but I think what we should then do is just take let's take a 10-minute break and resume at 20 to 1. Then we'll use that time, and at 1 o'clock we take the normal lunch break and then come back. So we'll adjourn and resume at 20 to 1.
All right.
Yes, Mr. Kwena. Good afternoon, Mr. Minister Mantashe.
No. Good afternoon, Chairman.
Thank you.
Mr. Chair, you will pardon my voice. It's that time of the year when one's body simply collapses. I'll try my best that I should be audible.
Yeah.
The Commission, Mr. Chair,
You want to consult your leader?
no, Mr. Chair, not at all. The Commission, Mr. Chair, will be calling as its next witness, Mr. Mantashe. Chair, you will recall that the Commission in its previous sittings, it did lead the evidence of the banks, and the bank's testimony was relevant to term of reference 1.7. You will also recall, Mr. Chair, that the banks testified about a meeting which was initiated by the ANC at the instance of the Oak Bay Group. Some of the banks, Mr. Chair, did attend that meeting with the ANC, while others did not. In fact, to be much more precise, Standard Bank, ABSA, and Nedbank did attend that meeting, and FNB did not attend the meeting with the ANC. And currently, Mr. Mantashe will be testifying in response to the evidence that was led by the banks squarely pertaining to term of reference 1.7. We know now that he's the chairperson of the ANC, and at that time, he led the delegation that met with the banks in his capacity as the Secretary General of the ANC. We have also made it clear to Mr. Mantashe and the ANC that even though today they will be limiting their evidence only to deal with the responses of the banks, they will be called in the near future to assist the Commission in also addressing other terms of reference. And in this regard, Mr. Chair, we are ready to proceed and call the evidence of Mr. Mantashe. May the witness be sworn in.
Yes, Registrar, I think probably it will be an affirmation with Mr. Mantashe. Administer an oath or affirmation.
He indicated that it will be an oath.
Sorry?
An oath.
Oh, okay. Thank you.
Please state your full names for the record.
My name is Samson Gwede Mantashe.
Do you have any objection with taking the prescribed oath?
No problem at all.
Do you consider the oath to be binding on your conscience?
Absolutely.
Do you swear that the evidence you will give shall be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you. Well, I understand, Mr. Mantashe, that today you are here not in your capacity as minister, but in your capacity as the national chairperson of the governing party, or as former Secretary General of the party. I simply mention that because you are one of the ministers at the moment, and I have been calling for present and past ministers who might have information that is relevant to the investigation of the Commission to come forward. But I just remembered that today you are here, not as a minister, but as one of the leaders of the governing party.
I agree.
Thank you. Yes, Mr. Mkwena, you may continue.
Mr. Mantashe, for a meaningful treatment of the issues arising from your witness statement relevant to term of reference 1.7, we have placed 2 Archive files before you. You will see, if you look at the spine of each file, they should be marked H1 and they go up until H6. Mr. Chair, we hope that those exhibits are also before you.
Let me just have a look. There is H1, exhibit H1A. There is exhibit H only. There is exhibit H3, H4. Then there is exhibit H2 and H5. Do I seem to have everything I'm supposed to have with me?
They should go up until H6. I suspect that the black file that is there should be the one that is marked H6.
No, I don't have that one.
This cannot be.
Is this the one? I see that I do have it, Mr. Mkwena, but the problem is a problem that happened, I think, last week, where on the spine it's written with very small words, so it's difficult to read them if the file is a little far. So I've got it, but will somebody, maybe during the lunch break, just make sure that the writing on the spine is one that can be easily seen?
Will do so, Mr. Chair.
Thank you.
Mr. Chair, prior to leading the evidence of Mr. Mantashe and the ANC have made a request that they should make an opening statement. As the legal team, we possess no power, no authority to grant such a request, and it is on those bases we deem it necessary to bring it to your attention and to seek your guidance and direction in that regard.
Is there a written statement that I can have a look at first?
Mr. Chair, there is a written statement, but we did not make it available to you up until you have provided the necessary.
Yeah, can I have it? No, that will be in order.
Mr. Mantashe, you may proceed. Should we not mark it first, Mr. Chair, so that at least we know when we look at the record what was Mr. Mantashe reading? And if it's so, can I propose that it should be Exhibit H7?
Okay, we will mark the opening statement that Mr. Mantashe is going to read as Exhibit H7. You may go ahead, Mr. Mantashe.
Thank you very much, Chairman. I am the National Chairperson of the ANC, and I address the Commission on behalf of my organization. When the ANC met the banks, I was the Secretary General of the ANC, a position I held for 10 years up to the 20th of December 2017. At the outset, I wish to put in context the importance of the work of this Commission and explain why all South Africans, both black and white, should embrace the Commission with open arms. As a ruling party in government, the ANC carries the obligation to build a South African nation and a strong, capable state. Since 1994, we have come to learn that there are no shortcuts or quick fixes to nation and state building processes. But the ANC exhorts all South Africans to persevere. We have to endure the pain and emotional trauma of building a nation with single national identity out of the ashes of a racially divided and inhuman past, and we have to build a strong, capable state from an exclusionary and illegitimate past. The Truth and Reconciliation Commission fulfilled an important role in the post-apartheid nation building process. As a young democracy, we've achieved in a relatively short period of 24 years a degree of consensus on past cultural traditions, customs, symbols, rituals, and the historical experience of black and white people. This proved to be a strong indicator of the willingness of the different racial groups in our country to come together for the common good. In just over 2 decades, we have succeeded in laying down a strong legislative, ethical framework of accountability and good governance. That compares favorable to countries that have been in existence since the evolution of the state system more than 350 years ago. The constitutional democracy and freedoms we enjoy today sits precariously on the sacrifices made by thousands of comrades who were exiled, imprisoned, maimed, burdened to death and hanged. We must jealously guard our victories and not allow anyone to drag us back to the racially divided society where the rule of law was selectively used and where the majority of people existed as soulless, dehumanized individuals. We should not shy away from our collective responsibility to protect our freedoms. We should not be deterred by fear. Again, against this backdrop, this commission stands as a reality check on, one, how far we have progressed as a nation, what values are shaping for ourselves, bequeathing to future generations, what lapses some members of the National Executive, past and present, suffered, and whether as a nation we have succumbed to the scourge of corruption. In the view of the ANC, this is probably the singular most important reason for the establishment of this commission, and equally, the primary reason why all South Africans should protect the commission at all costs. The ANC will make its submission to the commission in 4 parts. 1, today, the ANC will respond to the evidence given by the banks, explain why it met the banks, and what internal processes were followed thereafter. At a future date, I will be given an opportunity to respond to Comrade Barbara Hogan's allegation that I improperly and/or unlawfully sought to use my political influence to interfere in the management of Transnet by insisting on the appointment of Mr. Siyabonga Gama as the CEO of Transnet. In the same session, I intend to deal with Comrade Hogan's remarks about the NC's Polokwane conference and an allegation that I demanded that Mr. Gotzel should not be retained as chairperson of ESCOM board. In her oral evidence, which was not part of her written submission, Comrade Hogan alleged that Comrade Jesse Duarte, the Deputy Secretary General and a senior leader of the ANC, was part of state capture and that Comrade Ahmed Katrada was poorly treated. Comrade Hogan should be given an opportunity to withdraw or substantiate these allegations. For her part, Comrade Jesse Duarte is prepared to come before this commission at any stage to rebut the allegation that she was part of state capture and rebut any other allegation made against her. The ANC believes that a key output of the commission should be the relationship between the party and the state. When the commission makes time in the new year, the ANC will provide information about its deployment policy adopted by its National Executive Committee between January and July 1999 with specific reference to the deployment framework, guidelines for deployment to various centers, deployment and human resource development, coordination of deployees, organizational culture of the ANC, guidelines on the relationship between the constitutional structures of the ANC and government executive, guidelines on the role and criteria for ANC premiers, criteria for the appointment of premiers, the 50th ANC National Conference resolution on cadre deployment policy, and the 52nd ANC and National Conference resolution on organizational renewal. In his final submission to the Commission, ANC President Comrade Cyril Ramaphosa will respond to a broad set of issues relating to the ANC which arose in evidence before the Commission and will explain what action the ANC took and why it omitted to intervene in circumstances when it should and could have done so. To assist the work of the Commission, the ANC calls on all its members who may have information on the undermentioned terms of reference of the Commission to come forward with such information, whether, to what extent and by whom attempts were made to influence members of the National Executive, including deputy ministers, office bearers, and or functionaries employed by any state institution, organ of state, or directors of the boards of the state-owned entities. The nature and extent of corruption in the awarding of contracts, tenders to companies, business entities, or organization by public entities listed in Schedule 2 of the Public Finance Management Act. Whether there were any irregularities, undue enrichment, corruption, and undue influence in the awarding of contracts, mining licenses, government advertising in the New Age newspaper, any other governmental services in the business dealings of the Gupta family with government departments and SOEs, whether any member of the National Executive, and including deputy ministers, who unlawfully or corruptly or improperly intervened in a manner of closing of bank facilities for Gupta-owned companies, and the nature and extent of corruption in awarding of contracts and tenders to companies by government departments in particular, whether any member of the National Executive, including the President, public officials, functionaries, or any organ of state influence the awarding of tender to benefit themselves, their families, or entities in which they held personal interest. Finally, the ANC calls on all members to step up and answer the allegation made against them at the Commission. This is our opening statement I'm submitting to the Commission.
Thank you very much, Mr. Mantashe, for the opening statement. The time is 1 o'clock, so I think we should then adjourn, and we'll resume at 2, when then you can continue with giving evidence. So we'll take the lunch adjournment now and resume at 2 o'clock. We adjourn.